Okay, well, good morning, good afternoon, good evening, wherever you are and whatever time of the day you are watching this. As promised or as planned, I am running this webinar for you all, delivering this content to you all so that we can all be on the same page in relation to our our obligations as employers. So the title of the webinar is How Are Your Human Resources? This is a really, really important area of our business. The majority of you as franchisees in your centres employ staff, and increasingly, particularly in the franchising industry over the last 2 years, significant attention has been paid to the practices within small franchise businesses and within franchisors themselves. So let's jump in. Quick whip through our contents. We will be going through a number of matters today. Just to give some background, this will be a very tactical content delivery session. So very much about the specifics of what you need to do in your centres in relation to human resources. There will be additional content delivered in relation to recruitment, selection and appointment in a separate webinar at a different point. But this is just really to establish a base level of knowledge across our franchise network. So we're going to have a look at the law and the actual legislation surrounding workers in Australia, pay, leave entitlements, record keeping and pay slips, your obligations in relation to hiring employees, very importantly, your obligations in relation to workplace issues, performance management, a very a very contentious topic that I think is largely misunderstood in the Australian workplace. Some matters around flexibility, how to go about lawfully and legitimately ending employment, and then just some links, tips and tools for you at the end to continue your learning as you go. This space is obviously incredibly extensive, and we're actually very lucky in Australia. Fair Work Australia has probably the best website that I think is going around in relation to the delivery of content. So you can certainly get access to everything that you need. All right, let's talk a little bit about the actual law itself. So fair work and franchising is really, really important to know, and you probably already do, but as a franchisor, it's my obligation to remind you that you as franchisees who employ staff have the same workplace responsibilities as other employers. So just because we're within the franchising industry, you are not exempt in any capacity from the direct obligations that would support an employee in any other business context. Additionally to that, franchisors can be held legally responsible if their franchisees don't follow workplace laws. Hence the reason for this webinar, and some very important changes have been made over the last 12 to 18 months or so to ensure that franchisors are helping their franchisees to understand and meet their responsibilities under workplace laws. We as your franchisor can't just hold you at arm's length and say, well, what they do in their own centres is up to them. It's absolutely not the case, and we are required to assist you in being the best possible employers that you can. In terms of the actual legislation itself, the Fair Work Act 2009 governs all of these obligations. Sitting alongside that are more plain language regulations that can assist you in the actual practical application. An important piece of legislation that came into effect last year in 2017 is the Fair Work Amendment Protecting Vulnerable Workers Act. This piece of legislation was tabled and passed in direct response to the misbehaviour of some franchisors and franchisees. You've probably all heard of the brands that you can see on the screen at the moment: Domino's, 7-Eleven, Caltex, Michelle's Patisserie, Donut King, or you might have heard of Retail Food Group, which some of these brands fall in and under. Very important to note that despite the high profile of these cases, there have always existed protections and I guess liabilities to some degree in the Fair Work Act for franchisors and franchisees. Nonetheless, the space surrounding franchises in Australia at the moment is heightened, probably unfairly, because I would believe that the majority of franchisors are doing the right thing. But as it seems to go, when media get a hold of a story and certain things start to blow up, it can cause some trouble for the rest of the industry. Saying that, what did happen in those brands was absolutely unlawful, unacceptable, and certainly brought those brands and the franchising industry as a whole into disrepute. I don't expect you to read a legislation. If you're so inclined, knock yourselves out, but it's absolutely not a requirement for you to do so. But you do need to be aware of, I guess, where our systems, processes, and even information comes from. The majority of the information that I'm presenting to you today comes directly from the Fair Work Act. Brief background there into the legislative framework that sits behind human resources in Australia. All right, jumping into some more of the actual content I need you to really pay attention to. National employment standards. So there are workplace laws that apply to all employees in the national workplace relations system. The minimum entitlements are set out in the national employment standards and the award or agreement that applies to your business. The national employment standards, we call them the NES, are 10 minimum employment entitlements that have to be provided by all employers to all employees. The national minimum wage and the NES make up the very minimum entitlements for employees in Australia. An award, employment contract, enterprise agreement or other registered agreement can't provide any conditions that are less than the national minimum wage or the NES. They cannot exclude the NES. The 10 minimum entitlements of the NES are, number one, maximum weekly hours of work, which are 38 hours of work plus reasonable extra hours. Number two, requests for flexible working arrangements. Certain employees can request a change in their working arrangements. Number three, parental leave, which entitles people to up to 12 months unpaid leave, as well as the right to request an additional 12 months leave. Annual leave is number four, which is 4 weeks paid leave per year, plus an extra week for some shift workers. Standard number five is personal carers leave and compassionate leave, which offers up to 10 days per year paid personal carers leave, 2 days unpaid carers leave, and 2 days compassionate leave as required per event. Community service leave is standard number 6, which is basically unpaid leave for voluntary emergency management activities and leave for jury service. Jury service is paid in some circumstances. We'll talk a bit more about that later. Number 7, long service leave, which is paid leave for employees who have been with the same employer for a long time. This may be covered under the NES or applicable state or territory law. It's important for you to do some research in your state and territory. I can certainly help direct you. This is something that I think we're going to need to turn some attention to, given the tenure of some of our staff members, and make sure that we are accruing and accounting for this in the right way. Number 8 is public holidays, so a paid day off on a public holiday unless reasonably requested to work. Number 9, notice of termination and employment and redundancy pay for some employees, up to 5 weeks notice of termination and up to 16 weeks of redundancy pay. Again, we'll talk a little bit more about that later. And number 10 is the Fair Work Information Statement, a document that must be provided to all new employees. We will be giving you access to some new documentation in the coming months, which will hopefully make the administrative piece of hiring and maintaining lawful employment documentation a lot easier for you. Saying that, you can access that document very, very quickly and swiftly directly from the Fair Work website. Important to note, because I do know that we have a number of casual employees in our group, that casual employees only get NES entitlements relating to accrued unpaid carers leave, unpaid compassionate leave, community service leave, and the Fair Work Information Statement. All right, awards and agreements. So an award is a document that sets out the minimum wages and conditions for a certain job or industry. They apply automatically unless your employees are covered by a registered agreement, which, to the best of my knowledge, our employees are not. We certainly don't have a registered agreement at a group level. Awards apply on top of the NES and can include information on minimum wages, including annual wage or salary arrangements, the types of employment, for example, full-time, part-time or casual, extra amounts such as penalty rates, overtime and allowances, work arrangements, for example, rostering or variations to working hours, annual leave loading and arrangements for taking leave, superannuation, and procedures for consultation, representation and dispute settlement. A registered agreement is a document that sets out the terms and conditions that apply to a particular business or workplace. Like awards, the agreements can have extra entitlements, but they can't provide for less than the NES. Agreements can benefit a business because they're tailored to a workplace's needs. However, like I said, we don't currently have an agreement in place, and I'm not planning at this point to suggest that we do roll one out. I am pretty comfortable if we stick with the award that applies to our centres and conduct ourselves from there. So after lots of research and lots of conversation with Fair Work, I can confirm now that GymbaROo and KindyROO employees are covered by the Miscellaneous Award 2010 as it pertains to our Australian centres. I understand that there are various different wage rates, various different awards that may have been used in the past in relation to this, but I would like us to streamline and centralise the award that we do use so that we can provide better advice, we can provide better consistency, and we can make sure that we are conducting ourselves lawfully in relation to this. I don't want anyone to be concerned or to panic if they're not currently using the Miscellaneous Award. We will slowly transition all of our employees over to this in the next 6 months or so. Again, nothing to be concerned or panicked about, as we will make sure, as we are required to, that all of our staff are only the same or better off as we transition them to the more appropriate award. Employment contracts. Very important. So an employment contract can be in writing or it can be verbal. However, I'd like to strike a line through all verbal because it is critical that you document any and all employment relationships that you have. So it's certainly best practice to record your employees' terms and conditions when they're hired. This can be done in a letter of engagement or a more formal contract. I'm in the process of updating our letters of engagement, which I will share with you all once they've been reviewed as compliant with the Miscellaneous Award. In the meantime, some of you have asked for contracts, and I've been able to provide you with the base Fair Work Australia contract, which is compliant with the NES and the majority of the terms of the Miscellaneous Award. Again, to reiterate, a contract must provide the same or more generous conditions than the NES or any relevant award or agreement. A contract can't undercut an employee's minimum entitlements from the NES or any award or agreement, even if they agree to it. Very, very important, guys, that even if you have an employee suggest or say that, yep, that's fine, I'm happy with that, it won't cut it. At the end of the day, if you are held to account for your employment practices, an agreement by an employee to undercut or undermine any of the legislative framework will be null and void. So please be very, very conscious of that and be very, very stringent and strict in staying very close to the obligations that you're required to. All right, pay slips and record keeping. So an employee's minimum pay rate is set by the relevant award or agreement. In relation to GymbaROo KindyROO at this point, it is my intention to establish annually a minimum rate of pay for each of the roles that we have in our centres, just to provide some guidance to you. Now, those are minimums. If you choose to pay above that rate, you're well entitled to, but certainly you won't be able to pay below that rate. So I'm going to be contacting all of you, or some of you, not entirely sure yet, just to understand exactly what you are paying your teachers and assistants at this stage, to try and determine an appropriate and competitive hourly rate / salary for our staff. Clearly, pay rate and agreement can't be any less than the base pay in an award. Where there's no award, pay rates in a registered agreement can't be less than the national minimum wage. Now, we don't have any issues here. We're well and truly paying above the national minimum wage. However, what I would like to do is to bring some consistency to make sure that our staff feel like they are part of a group. I've heard a lot about getting paid more here or getting paid more there. Now, that is a reality, because centres will look for the best staff and some staff will look to negotiate. It happens. There isn't a lot that we can do about it, but if we establish a competitive baseline, I hope that we can start to eradicate some of that negative competition that we're seeing. In terms of what the actual award looks at in relation to minimum wage of pay, they look at the age of the employee, the job classification, duties, qualifications and level of responsibility, the type of employment, full-time, part-time and casual, and the hours and times that they work. Really, really important that if any of the factors change, then your employee's pay rate may need to change. I think it's pretty common, and it happens across most small businesses, you set and forget a little bit in relation to your employment agreements. We need to be very careful that we are reviewing our employment agreements regularly, and ensuring that if there are any changes, that we are either issuing new contracts or making an amendment to those contracts. And again, that's something that I can assist you with. A very important and understated, I think, employer obligation is pay slips. Now, if you're using a piece of accounting software grounded here in Australia, you should be pretty confident that your pay slips are compliant, as they are required to be so. But very important just to whip through this. So employees need to be issued with a pay slip within 1 working day of being paid. I cannot stress that more highly enough. This is very, very important. I've regularly been on the receiving end of employees who say, I haven't got my pay slip, it's been 2 days, 3 days, 4 days. That's illegal. You need to issue it within 1 working day. They can be issued electronically or in hard copy. It doesn't matter. I had someone ask me recently if their staff member had a full email inbox and they weren't actually receiving them. And I said to them, it isn't a matter necessarily of receipt. It's a matter of you guys being able to document that you have sent it within that compliant time frame. Of course, encourage your staff to empty their inboxes if they need to be able to get their information, but you have to have issued it to them and made it available. Some simple details that payslips must include are the employer's name and ABM. Now, the employer, guys, that is you. That is your legal entity. That is not Toddler Kindy GymbaROo, Pty Ltd. It is your name and ABN, the employee's name, the date of the payment and the period that the payslip covers, before and after tax amounts. If they're paid hourly, the employee's hourly rate, the hours worked at that rate, and the total amount paid at that rate. So I understand that we do have different rates based on whether it's an admin time, it's equipment setup and takedown time, teacher and assistant. So you need to very clearly separate out the different rates and roles that your staff are engaged in for each pay period. If they're paid a salary, it's a lot simpler, simply the employee's salary rate. Any loadings, allowances, bonuses, incentive payments or other separate monetary amounts. Any deductions, so this, for example, maybe it's for uniform or any other bits and pieces that you might have legitimately paid for on behalf of the staff member that they have agreed to deduct from their pay. And very importantly, superannuation contributions made or required for that pay period and the fund name or name and number. Guys, I can't stress again more strongly how important it is to maintain your superannuation obligations and to ensure payment on time. All right, record keeping. Again, this is another area where historically franchisees and franchisors have probably not been as diligent as they could and should have been. So this is a really good opportunity for you to review what you are doing, how you are doing it in relation to your record keeping, and identify any gaps that you've got that perhaps we can help you to fill. So you need to keep detailed records for each employee about their employment, such as pay, hours of work, leave, superannuation, and any other matters. Record keeping and payslip obligations ensure employees receive the correct wages and entitlements, and you as employers protect yourself by being able to show that you have paid employees correctly. The records must be in a form that is readily accessible to a Fair Work inspector, should they call on you. They need to be legible and in English. They must be kept for 7 years, irrespective of whether the employee is still in your employ or not. They are not to be changed except for purposes of correcting an error, and they're not allowed to be false or misleading to the best of the employer's knowledge. So again, I'd like to reiterate, please take a moment to have a look at your employee records, and if they need a bit of an audit or a bit of a tidy up, now is the opportunity. As a franchisor, we are actually required now to commence auditing your employee records. Again, not to frighten you or threaten you in any capacity, but we will be required to commence a compliance process in relation to this relatively soon. So jump in and have a look. That process will not be punitive. It's about being proactive and ensuring that we're doing all of the right things. Okay, leave. So clearly employees take leave for many reasons, including to go on holidays because they are sick or to take care of sick family members. Minimum leave entitlements come from the NES, and an award or agreement or contract of employment can provide for other entitlements, but they can't be less than what's in the NES. Now, under the miscellaneous award, we essentially follow exactly the same as the NES. So in relation to annual leave, it's 4 weeks paid per year. That applies to our full-time and part-time employees, but not to our casuals. Personal or carers leave is 10 days paid per leave, again, for full-time and part-time employees. Community services leave is unpaid except for jury duty make-up pay. And what make-up pay is, it is the difference between what a person gets paid by the government to engage in jury duty and what they otherwise could have expected to earn if they were in their usual employment. Compassionate leave, so that does apply to all types of employment, and it is 2 days per event. So say somebody was to pass away in the immediate family of one of your employees, they will be entitled to 2 days per event of paid compassionate leave. Parental leave, as I said, up to 12 months with an option to extend for a further 12 months. It's applicable to everybody, irrespective of their employment classification. And long service leave, refer to the award or the state and territory legislation. I can help you navigate your way through that if you have any issues. Again, it applies to full-time and part-time employees only. All right, hiring employees. Now, guys, just want to stress before we jump into this that this isn't about recruitment and selection processes. That's an entirely different set of content which we will deliver to you. This is more about ensuring that when you are bringing somebody into your centre, that you are dotting your I's and crossing your T's in relation to setting them up. So, very important decision for your business to hire a new person, and clearly you need to ensure that you find the right person that suits your culture and your centre. And most importantly, though, guys, you really need to meet your obligations at this juncture. So once you've recruited a suitable person, you've got to follow these steps. You need to determine the classification under the award. Again, I'll be assisting you to do that going forward by providing you with a guide to that. You need to decide whether the person will be full-time, part-time or casual, and whether it's permanent or temporary. It'd be good for you guys to do some additional reading in relation to casual employees, and I can provide you with those links. Casual is not as simple as it was back in the day, so to speak. Casual employees can actually quite quickly become conceived as permanent employees based on the predictability and regularity of their shifts. So really important for you to understand that distinction, and we can talk about that further if you think you might need to. Obviously, we need to issue a letter of engagement or an employment contract. Alongside that, a position description. Again, something I would like to provide is updated position description templates for all of you so that you can have up-to-date content in relation to what the expectations are for each of the roles that we hire for. You need to provide your employees with a Fair Work information statement, a superannuation choice form, a tax file number declaration, and we have recently updated our staff details form, which following this I will provide to you so that you can collect all of the information you need to about your employees, about their next of kin, their emergency contacts, their bank details, and any other information that you might need to collect. Now here's a big doozy that's hit up a lot of people in the franchising industry, certainly in the industries that I've worked in previously, in physiotherapy and in the fitness industry. There was prolific use of independent contractors, and I don't think maliciously, but unknowingly, a lot of franchisors and franchisees got caught out for misusing the notion of an independent contractor. So really important to clarify. An independent contractor is someone who is self-employed and contracts their services to clients. Independent contractors are not employees and have different rights. It's really important to understand the difference between independent contractors and employees and give them their correct entitlements. Just because a worker has an ABN or issues invoices doesn't actually make them an independent contractor. And labelling people as contractors or getting them to sign contracts which state they are doesn't actually mean that they are either. Misrepresenting or disguising what is actually an employment relationship as a contracting arrangement is known as sham contracting, and it is against the law. Similarly, dismissing or threatening to dismiss an employee to engage them as an independent contractor is also against the law. So if you do employ people as independent contractors in your business, please have a read. There's a link at the back of the presentation. Please have a read about what your obligations are and make sure that you are following them and that you are not engaging unknowingly in any sham contracting. Okay, workplace issues. Really, really important. This is where I guess the rubber hits the road in relation to relationship itself and where things can get pretty contentious if for whatever reason the working relationship goes sour, there are disputes, there are conflicts. So often workplace issues arise because employers and employees don't actually know what the law is or what their obligations are, and usually 9 times out of 10 it's because communication has broken down. So if problems arise in the workplace between you and your staff or even between your staff themselves, it's important to take the time to understand and discuss the issue with your employees. Most workplace issues can be resolved with the right tools. So first thing to do, check the process. Most awards and agreements have a dispute resolution procedure. Certainly the miscellaneous award does. Some businesses also have a formal set of processes for dealing with workplace issues. We don't currently, but we will into the future. So for the time being, we will default to the award. Second big step is to actually discuss the issues. So, prepare yourself for the conversation. Understand what it is that you're trying to achieve. Are you simply at the stage where you just need to listen and understand, or do you have enough understanding that it's time to start working together towards resolution? Set the time up to talk to your employee without any interruptions. So don't rush into a conversation. Try and do that face-to-face. Try and sit down with them when you've got more than enough time to understand their perspective and where they might be coming from if they are having issues. Most importantly, listen, listen, listen. Keep an open mind and consider all points of view. I think certainly in my experience, taking the opportunity to just listen and absorb information, maybe going away with that information, having a think about it, sleeping on it for a few nights before you come back and perhaps have a second meeting or a follow-up to discuss how resolution might come about is a really good idea. You might have lots that you want to say or lots that you think is important. Just check yourself as an employer when you're in those conversations. Try not to be adversarial, try not to be combative. Even if you feel that the content is unfair or etc., anything that you're not necessarily happy with, just hold your tongue in that first instance. Listen, keep an open mind and consider the points of view. Once you do have all of that information, it's a really good idea to put any agreed actions down in writing. So you put it in writing, that's just been in an email to the employee. Hi, Emily, thanks so much for your time. The issues, as I understand them, are ... The actions we've agreed to are ... Can you confirm that this is your understanding of the conversation that we have had? And let's agree to touch base again in 2 weeks' time to see how things are going. Obviously, you want to get that engagement back from the employee to confirm that that is their understanding, so that if anything were to continue to deteriorate or if things were to flare up, you have that record that a conversation was had and certain actions were agreed to. All right, performance management, or actually, as it is probably much more appropriately called, managing underperformance or managing performance. I think that performance management has become synonymous with exiting people from businesses. So people go into performance management in inverted commas when things have gone to such a point that an employer thinks that their employment is no longer tenable. That is not the intention at all of performance management. So this is really critical content for you guys to think about. But knowing how to manage underperformance is very, very important. If it's not handled quickly, well and sensitively, it's likely to have consequences for you, your employees, your families, and the rest of the workplace. So good employee management, guys, is linked to lower staff turnover, higher productivity, and better business success. In my opinion, effective managers know how to motivate and communicate with their employees. They also understand their legal obligations and promptly and in real time deal with any problems that arise in the workplace. So a simple process here to help you get the best from your employees is to implement a performance system. And if you take a look here, the 4 steps are to plan, to discuss, to monitor, and to review. So starting with plan. Review your organisation or your top-level business goals and then consider how individual performance goals help achieve those business goals and how you're going to apply them to the separate staff members in your business. Create a performance agreement template for your workplace. Engage your team in that. Share that with them. Share it, make it a collaborative process and ensure that you are all on the same page. Once you have the global business plan or your business goals ready to go, meet with your individual employees then to discuss their individual goals. Discuss with them any skills that you think they need to develop and how they might go about doing that. And then record them in an individual performance agreement. Clearly, then you need to monitor your employee performance, provide regular feedback, both positive and constructive. You need to deal with performance issues as they arise and support employees to improve performance. So the whole, foundation of performance management is to try and increase performance, to try and better an employee's experience within our organisation. It is not intended to be a tool that gives 3 strikes and you're out. And in fact, I've been in many situations where it has been used as a big stick tool, and with nearly 100% surety, it goes very, very badly. It's a positive tool. It's meant to be about making your business better, making individuals better. And so lastly, of course, you need to review. So you need to be conducting reviews with your employees every 6 to 12 months to assess their performance. And in those reviews, revise performance goals and set new ones for the next performance cycle. Very important here. I do not want people waiting 6 to 12 months to talk about performance though. It's really difficult when you're sitting in an annual performance review, for example, and your manager goes, now, in February last year, I noticed that you didn't follow the neurological theme properly. Why was that? Very unhelpful. We need to be talking to our staff members in real time. It builds culture, it builds trust, it builds accountability, it builds responsibility. Those 6 to 12 month formal business reviews should be much more organisational and high level about how the individual performance is feeding into the business's performance, rather than the minutiae of day-to-day things that may or may not have been done. So again, I hope to be building some tools that you can all use in relation to this, but really important for you to start thinking about what you want your business goals to be and how we can include our staff in that process. All right, flexibility. I think flexibility is something that we really do really well. The very premise of our business has been that it does provide for significant lifestyle benefits for our employees, but nonetheless, there are some formal ways that we can make the workplace more flexible. The flexibility in the workplace allows employers and employees to make arrangements about working conditions that suit them. It helps employees to maintain a work-life balance and can help employers improve the productivity and efficiency of their business. As long as employees are still receiving their minimum entitlements under their original employment contract, employees can negotiate ways to make the workplace more flexible. Examples include sort of changing what hours are worked and where work is performed. There are two formal ways employers and employees can make their workplace more flexible. The first is flexible working arrangements. Certain employees have the right to request flexible working arrangements. For example, parents with children under school age have a right to request flexible working arrangements, perhaps to work from home, perhaps to work school hours, perhaps to have school holidays off. There could be numerous things. And then secondly, there's individual flexibility agreements where employees and employers can negotiate to change how certain terms in an award or agreement apply to them. So very important. I would certainly, I'm very passionate about making work-life balance a reality in the organisations that I work in. I think that it really does inspire motivation and engagement from employees, certainly where I've been able to provide people who have worked for me with that flexibility in the past. It's been a really positive experience for both them and for myself and for the organisations because the work gets done just in less traditional ways and less conservative ways than perhaps we've been used to in the past. So have a think about that. Have a think about if there are any employees that I guess you could work with to make things a little bit more flexible, and also, really importantly, have an open mind to flexibility when you are employing new people. See how you can make it work for you. All right, important, ending employment. So notice of termination. Termination of employment is clearly when an employment relationship ends. This can happen for a number of reasons, including redundancy, resignation, or dismissal. Full-time and part-time employees are entitled to a notice of termination or payment in lieu of notice, and this notice needs to be given to them in writing. The amount of notice depends on the employee's length of service and their age. It's important to check the award, employment contract or agreement to see whether there are any conditions and if a longer notice period is required. As you can see here, in relation to the miscellaneous award, the period of continuous service and the notice periods are spelled out: 1 week, 2 weeks, 3 weeks and 4 weeks. And for any employees over 45 who have worked in the business for at least 2 years, they get an extra week of notice. Redundancy. This happens when an employee's employment is terminated because an employer either doesn't need an employer's job to be done by anyone, or the business becomes insolvent or bankrupt. Redundancy can happen when the business introduces new technology, slows down due to lower sales or production, closes down, relocates interstate or overseas, or restructures or reorganises. Important for us, guys, is that, When an employee's job is made redundant and their employment is terminated, their employer, in most circumstances, has to give them redundancy pay, which can also be known as severance pay. The amount of redundancy pay depends on the employee's length of service and the relevant award or agreement, but it doesn't need to be paid to some employees, including employees who have worked for less than 12 months, employees employed for a specific task, project, time period or season, employees terminated because of serious misconduct, casual employees, apprentices, trainees engaged only for the length of their training agreement, and very importantly for us, some small businesses that have less than 15 employees. Really important for you to understand whether or not redundancy pay does or does not apply to you. In most instances, in most of our centres, given that you guys are the individual employers of your staff, I would imagine that redundancy pay would not apply. But if that does happen, we will, of course, navigate that consciously and carefully. Final pay, the amount of times, guys, that I see people trip up, that I see organisations, employers trip up here and get this piece wrong, leading to a really ugly and disappointing end to an employment relationship. An employee must get the following entitlements in their final pay: any outstanding wages for hours they have worked, including penalty rates and allowances, any accumulated annual leave if they're permanent employees. If it applies, any annual leave loading, accrued or pro rata long service leave, and any redundancy pay. Sick and carers leave is generally not paid out when employment ends. And again, very important, employees need to be given a pay slip with their final pay on their final day. Please do not allow it to go any longer than that. Important point here, you aren't automatically entitled to deduct money from an employee's final pay if they don't give notice or fail to return company property. On so many occasions I've heard franchisees say, well, I'm just going to dock their pay because they haven't returned their uniform or they haven't returned their keys. You are not lawfully able to do that. So please check your obligations in relation to deductions. Okay, unfair dismissal. Very, very important matter, unfortunately very prolific in small business. Again, I don't believe maliciously, I simply think it's ignorance more than anything else. So let's get upskilled and make sure that we are being very conscious about how we terminate our employees. So unfair dismissal is when an employee is dismissed from their job in a harsh, unjust or unreasonable manner. Businesses with less than 15 employees should use the Small Business Fair Dismissal Code and Checklist to make sure that a dismissal is fair. I've provided you with a link to that in the back of this presentation. I encourage you all to read it. Okay, some protections at work. All employees have protected rights at work. These protected rights include workplace rights. A person has a workplace right if they have a benefit, role or responsibility under a workplace law, for example, the Fair Work Act. An instrument, for example, an award or agreement, or an order made by an industrial body, for example, the Fair Work Commission. A person has a workplace right if they can start or take part in a process or proceeding under a workplace law or instrument, if they can make a complaint or inquiry about their employment to a body, and if they are an employee and can make a complaint or inquiry about their employment. The second protected right is to be able to take or not take part in industrial activities or belong or not belong to an industrial association. So a person has the right to belong or not to belong to an industrial association, for example, a trade union or an employer association, and a person has the right to take part or not take part in any industrial activity. Lastly, and really importantly, our employees have the right to be free from discrimination. So an employee or a prospective employee has the right to be free from discrimination at work. Discrimination occurs in the workplace where an employer takes adverse action against an employee or prospective employee because of a protected right attribute. The protected attributes include race, colour, sex, sexual orientation, age, physical or mental disability, family or carers' responsibilities, and pregnancy. Adverse action includes doing, threatening, or organising any of the following: firing an employee, injuring the employee in their employment, for example, not giving an employee their legal entitlements such as pay or leave, changing an employee's job to their disadvantage, treating an employee differently than others, not hiring someone based on a protected attribute, or offering a potential employee different and unfair terms and conditions for the job compared to other employees. This space is a minefield, clearly. There are other things as well that would sit in here. Bullying and harassment is also a key one that seems to be getting a lot of momentum within the workplace. And even if that isn't employer to employee, but is employee to employee, you as the employer still have some obligations. So we'll also be doing some additional specific work on bullying and harassment in the workplace, because that is getting more and more attention. So guys, that actually brings me to the end of the content delivery. I know that there is a lot in there and I could probably talk for even longer. Really importantly, I've put in the back of this presentation, which I'll be sharing as slides for you, the key links to what I've discussed with you today. So that's the NES, some information about independent contractors. The Fair Work fact sheets pretty much cover off every single topic that we've talked about. So I encourage you to go onto the website and have a look at the fact sheets as they pertain to anything that caught your attention or that you feel you may not necessarily have all the information that you need in your business. Redundancy, deductions, unfair dismissal, and general help. As I said to you earlier, the Fair Work website and Fair Work Australia as an organisation are an absolute, they just provide the most amount of information. You really can't go wrong with them. They are so helpful. You can jump online and register. You can register yourself as an employee and get as much or as little advice as you need. But really, despite the fact that there is just such a mountain of information in relation to this area, they make it really, really easy for us as employers to do the right thing. So take advantage of that, and in all the spare time that I know you guys have, in inverted commas, do a little bit more reading. All right, that brings me to an end. Thank you so much if you have made it all the way to the end with me. It is absolutely still my intention to open up some live forums for us to have further conversation about these matters, and I will post those dates and times in our next weekly update. As I said, thanks for sticking with me. A very, very important topic, one that I am very passionate about, and an area that small business owners just cannot afford to be complacent in or get wrong. So lots more action to happen in this space in the next 6 months. We will do everything that we can to provide you with the tools and templates that you need to be the very best employers that you can. Thanks, guys. Have a good day, evening, weekend, whatever might be coming up next for you, and I look forward to connecting with you soon.